indicated some members are with us online. I think member Malahu Fort is supposed to be joining online also. Sorry, let me just deal with this, yeah. Okay, so we will just go straight into it with the reading and the confirmation of the minutes held on October 13th. Are we able to go through those now? Have members had a chance to review them?
I haven't, Chair.
You have?
Haven't.
You have not. Any persons online who wish to make a comment read the minutes, or should we defer this until later when we have had a chance to possibly review them? I myself went through and found them to be in keeping. We only have one member other than myself here in chamber, so we will heavily rely on communication from the members who are online.
Chair, I have no difficulty with the minutes. I did have a chance to review them.
Okay, so we probably should defer them until later on. All right? Okay, and likewise, item number 6, matters arising from the minute. So let us just go straight into the clause by clause, continuing the review of the summary sheet that was circulated with the decisions made and being considered. This last meeting was back in October last year, so this is really, and I should indicate that this is our first meeting for the year. Oh yes, I completely did not realize that. So a belated Happy New Year to everyone, and welcome back to hopefully the final phases of the Tobacco Control Bill execution review. All right, so yes, let's just go straight into clause 1. We all have the summary sheet with us. So we should start. Yes, thank you. All right. So Ms. Brandon had indicated exactly where we can probably start from where we left off last time.
Excuse me, morning, Chair?
Yes, good morning.
Yes, I apologize for being late. Marlene Aldred. In the definition of public place, I think it should be revisited because where it talks about the right of access, we have to make sure it means the public who has that right of access. And where the words the public are, it's way up in the clause.
SG, could you refer us to the...
Well, I thought we were looking at the revised amendment sheet. When Chair said clause 1, so I thought we were looking at the revised amendment sheet. That's
No,
not...
I think there was a suggestion coming from Ms. Brandon as to where...
So both are correct. So we are looking at the revised document that was sent yesterday.
And I'm on page 1 of that.
And you're
document.
on page 1 of that, but Ms.
Yes.
Brandon was just kind of indicating where we had left off from the last meeting. So
right.
Yes,
so
Ms. Aldred.
I understand, but I just wanted to point out that I had an issue before. I think that would have been maybe clause 8, page 6 or 7 is probably where Ms. Brandon was taking it to, but just to say that in the definition of public place, so it lists some places and then says available to be used collectively by the public. Then it has some other words, and then it speaks about or right of access. I think where it needs to be clear that that right of access is also relating to the public. I think where the public is, I'll speak closer into the mic. I think where the words the public is, it's too far removed from when you talk about the right of access. And I don't want there to be any misinterpretation because this right of access means to the public.
So we somehow need to connect that to the original stem of the interpretation.
Yes, I mean it's for the drafters. It's just that when I read it, I am not sure that it is as clear as it could be.
But what other possibility could it be, if not right of access to the public?
Because remember, we're talking about a public place, and we're trying to make sure that this is right of access to public at large and not just private individuals.
Any opinions,
meaning we
any
want to make sure that we are distinguishing between public place and private place.
I recognize. I'm just wondering because it is directly related to the original
So, for instance, in the Interpretation Act, where it talks about right of access, it uses the words the public right there.
Okay.
Right at that point.
So,
because you don't want any...
What do you recommend? How do you recommend we adjust it? Let's consider.
Oh, no, I'm not the drafter, so I'm just pointing out that it needs to be very clear that when we refer to the right of access, we are referring to the public.
So you want to say right of access of the public to?
It would be for the drafters. We have two drafters here.
Okay. Thank you. Any comments?
Chair, I think I understand what the SG is saying, and I think her suggestion correctly that the drafters look at it be something that we could have them look at, but we could move on whilst they look at that particular point, you know?
Yeah, thank you, Madam Chair. Yes, we note the comment, and we will, as a technical team, take it on board to make an appropriate adjustment in the interest of clarity.
Okay.
Thank you.
All right, duly noted. Thank you, SG. All right. So let us move now to Clause 7, which is where we were at our last discourse. Sorry.
Madam Acting Chair, may I make a general comment in relation to this document that we are using?
Which document?
The latest version of the suggested provisions.
Yes, please.
And it is to indicate, for the benefit of the members and others attending the meeting, that this document is largely reflecting previous decisions, and what we have sought to do as a technical team out of the Ministry of Health is to highlight the modifications. So you'll notice that there's some highlighting of some provisions, yellow highlighting for the most part. And that was really to make the progress through this meeting a little easier. So we just make that point to indicate that as far as possible we have sought to highlight the provisions where there have been changes made since October. Thank you.
Okay, thank you. Duly noted, Mr. Edwards. Thank you. Welcome, Member Gale.
Thank you, Chair.
Yes. So we will go straight into the interpretation of Clause 7, policy of the government in relation to tobacco control. In this part, does... Right. So it was agreed that clause, I'm reading from the sheet of the summary sheet of the decisions first. It was agreed that clause 7(1)(c) and subclause in 2 and 3 were to be deleted with the redraft of a provision, and the clause would only be limited to the power of the minister to develop a policy framework. I remember this one had much discourse at our last meeting. Clause 7(1)(a) and (b) would then become clause 4(1). The revised Clause 7 to be redrafted to be a definition provision for the new provisions dealing with the conflicts of interest and limitations of interactions. And the term interaction should be extended to include business forum in relation to the tobacco interests. Now, Mr. Edwards was to review the term appropriate public body since it was not used in the bill, and also the further consideration to be given to the definition of security forces. And again, as reflected in the minutes, those two discussions were quite fervent. So now to the recently submitted revised extract. Appropriate authority in relation to public officials, so revising the term appropriate public body. Appropriate authority in relation to public official means the individual or entity who directly or ultimately has oversight of the official conduct of the public official. Whereas appropriate public body is in relation to the public official, means the public body that the public official is employed to, contracted to, or otherwise serves within. And interaction means a meeting or any correspondence between a public official and tobacco industry, or other exchange between a public official and the tobacco industry that arises when the public official meets with the tobacco industry in a common or business forum. So, do we have the original clause? Can we have the original clause that we can?
Madam Chair.
So, Madam Chair, is it therefore contemplated that in clause 2, we are going to be including that as a definition?
Well, go ahead.
If I may, thank you. The intention was, as far as possible, to create an interpretation provision that would apply for the purposes of this part. So if these terms are only going to be applicable for use in this part of the Act, we sought to have an interpretation provision that was dedicated to this part of the Act, because some of these terms will not be of general use and they may create conflict if they appear in Clause 2. So the intent really was that except where the term is going to be intended for general use throughout the legislation, that these terms were to be included in an interpretation provision for purposes of this part only. If Member Guy may be raising a question of some of these terms also appearing elsewhere, where we're not sure if that is the issue. So if they appear elsewhere and they can be of use in interpreting other provisions of the Act, then of the bill, then it would be more appropriately placed in Clause 2. But for the most part, we sought to state here terms that will be used for the purposes of this part, which deals with interactions with industry. Thank you.
Chair, if I may,
Yes,
Marlene Albright
go ahead,
again.
please.
Okay, so just to go a little further now, these are really terms used in Part 3 to deal with limitation of interactions with the tobacco industry. And then there was a lot of discussion about these terms. What you will see highlighted, well, you'll see public official highlighted on page 7, and then you will see two terms highlighted on page 8, specified public body and specified public official. I assume that these are here, especially the specified public body and the specified public official, because of our constitutional dictate that we did not want to have the remit too wide. We weren't going to be talking about just any civil servant or any public officer. We were going to be very specific about the public officers to whom this part would apply. Hence the terms specified public body and specified public official. In light of that, I don't support us still referring to appropriate public body, appropriate authority, and security forces, because...
Sorry, what was the second one you said? Appropriate authority?
Appropriate authority, appropriate public body, security forces. Because the persons you need to capture should be in specified public body and specified public official. Granted, you still need to define public official because that term is used in specified public officials. I have no difficulty with that. I just don't see the value of the other terms that I have pointed out, because we are trying to limit the persons to whom the part would apply, because this is an issue, this is a constitutional issue where we are limiting interaction. This is a freedom of association issue. And so if the committee perhaps could look at the definitions of specified public body, specified public official, and public official, and perhaps consider those definitions. If you are good and happy with those definitions, then I don't see why you would need the other terms.
Okay.
Such as, not such as, you wouldn't need appropriate authority, appropriate public body, and security forces.
Okay. Duly noted. Yes, yes.
Yes, Madam Chair. Yes, I note the Solicitor General's comments carefully. But I would just ask if we could look at how the term appropriate authority is used. For example, in the proposed clause 8.3, and 8.3 on the, it says page 9 of the summary sheet of the suggested text, page 9. Mm-hmm. It is used in the context of putting a duty on the, in this case, specified public official to communicate with that person's superior. So it was used in that context
of appropriate authority.
Of appropriate authority. So if we take out the reference to appropriate authority, then we wouldn't have that procedural step.
Go ahead. You perhaps use another.
Okay. I think 8.3 should refer to the specified public body, and not an appropriate authority.
No, there is no. If you see specified public
official shall state in writing to the specified public body. Yes. We are limiting the application of this to the persons in the definition of specified public body and specified public official. Why are we going outside?
SG, could you, I didn't hear you so well a while ago.
Okay, so I'm saying that I don't see why 8.3 is referring to an appropriate authority. I think the specified public official should be stating in writing to the specified public body that the interaction does not imply an endorsement. I'm saying that Part 3 should really be addressing either the public body whose functions include the developing, implementing, or enforcement is in brackets, of public health policy, and it should also apply to the specified public official who is a public official who has functions in the capacity as such that have a role in the developing, implementing, again, or enforcement is in square brackets, of public health policy. I still do not understand why we would be trying to target persons outside of whoever falls within specified public body and specified public official.
So you're essentially seeking to zone in on the specific
That's correct.
relevant authorities, but also giving more responsibility rather than just saying appropriate officials. The specified public official would then now be required to relate exactly to the individuals relevant.
Yes, yes, Chair.
Any other comments?
Well, it's just that what we would have to do then is, I understand the point made by SG. What we'd have to do then is elaborate in 8.3 which body we're referring to, because we could have several specified public bodies dealing with tobacco control activities or functions. So we then have to, the whole idea of the definition was to abbreviate the reference. So what we'd have to do in a case like that is say the specified public official shall state in writing to the specified public body, you know, to say something like this.
But if we're not doing that for appropriate authority, which probably is a bit broader.
It was deliberately broad because it was broad enough to cover both the cases of the specified official.
As being suggested, specified public, but isn't that more?
It's not.
Directly,
it's not.
It's almost already describing.
No, with respect, Chair, that is a broad term in this context because you have several specified public bodies. If there were only one body that were dealing with tobacco control, it will be fine. But you may have several agencies that have elements of functions. So you can't
so if
say...
you weren't listed it
Madam
for
Chair.
appropriate authority. Yes, please go ahead, Senator. Sorry, Mr. Edwards.
Madam Chair, I think I understand the point that Mr. Edwards is making, but the fact of the matter is that the definition of specified public body is not limited to a particular entity. It's specified public body speaks to the public body whose functions include, and there would be, by this definition, more than one public body that falls under that. So it is for the specified public
Official.
to state in writing to the specified public body. I mean, if you want to say to the appropriate specified public body without defining appropriate so that it's using its common parlance, then that might solve your problem. But I agree that to create a definition of appropriate authority here, because what Mr. Edwards is saying, from what I understand, is not that we're broadening the definition, that there is another authority outside of what we have defined for specified public body, but rather that there are more than one specified public bodies that fall under that definition. So it's for the public official to write to the appropriate one, right? So I think SG is correct that we are creating an additional problem by the use of appropriate authority, and we can continue to limit it to the definition we have set out of specified public body. And I am suggesting, Mr. Edwards, for your consideration, that the common word appropriate may be placed in front of that so that the specified official is writing to the relevant specified public body at the appropriate time.
Thank you, Senator Golden. And duly noted. Let us just review the definition, the actual definition that is suggested for specified public body, if we really don't need to go into that delineation as you suggest, Mr. Edwards. It means a public body whose functions include the developing, implementing, or enforcing of public health policy with respect to tobacco control. I think that is very clear as to who said public official needs to reach out to. So now to say that we will now go to delineate it. SG, what do you think about the suggestion of having the appropriate specified public body? Or further complication?
I think that would work. My specific issue was with the definition of appropriate authority on page 6, because it just referred to the very general definition, the very general term public official, and did not refer, for instance, to the specified public official. So that was really my issue, same issue I have with appropriate public body. So however it is addressed, I mean, I don't think those terms are needed. I think it can be done in a way so that it is very clear that the specified public official would go to the specified public body to whom that specified public official is employed or to whom they report to.
Well, as it is defined.
I mean, I don't think...
As is defined for specified public body.
Yeah.
Chair.
Yes, go ahead,
Hi,
please.
thank you. I'm in agreement with the Solicitor General.
Could shift your mic a little closer? Thank you.
I'm in agreement with the Solicitor General's comments in terms of addressing the concern for Section 8, subsection 3. The intent here is that the specified public official would be stating in writing to the specified public body to which he's employed, following the discussions at the last sitting, to state that this interaction does not imply an endorsement of the tobacco industry. So he's making a record to the employer. So that would define the specific public body to whom he or she is writing to. In addition, I wanted to also invite consideration of the use of the term public body, as it has a specific meaning within the Public Bodies Management and Accountable Act, which is a government company or a statutory body and excludes an executive agency. So we may want to consider whether we want to adopt the term public entity, which would include ministries. So it would be a specified public entity.
Can you repeat what their quote of a public body is?
In which okay, all right, let me just check.
No, I'm referring to clause 2, which is the definitions, and says that a public body means a ministry or department of government, including a statutory body or authority, a government company.
Thank you, I'm guided.
Mm-hmm.
So it covers the point that you were making. Okay.
Okay. So are we resolved? Shall we adjust it to appropriate specified public body or just specified public body? Are we not resolved? No?
Madam Chair, I think we're resolved, but I think the resolution will include taking words out of the current proposed definition for appropriate authority and taking elements of those, taking words out of that, putting them into subsection 3 to make it very clear that the person to whom the person is writing is a person in the authority that has responsibility for that specified public official's functions. So we would have to take some elements out of the definition, put them into subsection 3, and therefore speak of the specified authority to which the specified public official is employed to contracted to or serves within.
Okay.
We will have to do that because we're speaking of using the terms appropriate and relevant. Those words, as we would appreciate, without a context, do not have a clear meaning. So we would have to put some words to tie down what we mean by appropriate or relevant in the context of the specified public body to which the specified public official is connected.
Chairman,
Senator Allen, go ahead.
Yes, I was clear up to the point where Mr. Edwards just added the additional words. I was clear and satisfied with appropriate public body. And now I'm confused. So he's saying
specified
that
public body.
Appropriate specified,
Yes,
right. I was fine with inserting appropriate and would be satisfied with the definition there. But he's now saying that there's additional definition or contextualizing to take place, which would then substantiate the inclusion of appropriate specified public body.
No. Senator Allen, can I ask this?
Yes, please.
Through you, Chair.
Yes.
What Mr. Edwards is saying is that the current definition of appropriate authority, which sets out that it's the authority that the public official reports to, he would use some of the words there, the words used to define appropriate authority, and insert them into subsection 3. I'm suggesting that we have agreed in principle with the SG's point, and I think it's what we're really talking about now, which probably we should just leave to Mr. Edwards, is the specific words and the adjustment that needs to be done. I think he's clear on the principal point that we all agree on.
Yes, agreed.
Wonderful. Thank you very much.
Yes, thank you. That's exactly where we were going now. So I think we will look forward to the adjustments.
Yes, Madam Chair. Yes.
Okay, thank you. All right. So now we go to the consideration regarding the definition of security forces. Yes. Sorry. All right. So we are now. Where is that one now?
It's on page 8, Madam Chair. Security forces in brackets.
Oh, yes. Security forces means, okay, any member of the security forces, meaning the Jamaica Constabulary Force, the Jamaica Defense Force, and the Rural Police. The inclusion of security
Chair,
forces
again,
remains to
my
be
comment
determined.
is And my comment is, since we are targeting Part 3 to very specific persons who are captured under the definitions of specified public body and specified public official, I don't see why we're including a definition of security forces.
You're saying that they would be covered by this particular specified public official?
Or not, but the point is we are targeting very specific persons to whom Part 3 will apply. And I thought those persons are captured in the definitions of specified public body and specified public official. I think if the committee is not happy with those two definitions, then I think that is where you make the adjustment.
So you're suggesting, SGs, therefore, that we don't need to have a definition of security forces?
No, I don't think so. I think if we want it to apply to certain persons, we must ensure that those persons fall under the definition of specified public official.
So you're therefore, are you therefore saying that in terms of the definition of specified public body or official, that we should in some way craft to include security forces?
No, and my first question was, why are we including the security forces? And you will recall at the last meeting as well, I did not understand why we were including the security forces, and I'm still not satisfied that they should be included. But I am going on further to say, rather than have the bill being so cumbersome, I just think it would be easier to have with the terms specified public body and specified public official address all the persons and entities you want Part 3 to apply.
Madam Chair?
Please, go ahead, Mr. Edwards.
Yes. I appreciate the recommendation from Solicitor General to include all the categories in the definitions of specified public body and specified public official. However, that would be appropriate if we did not need to use terms relating to other public officials or other public bodies, because Part 3 is also applying to other public bodies and other public officials, not just the specified ones. There's Clause 8, the proposed new Clause 8, hones down, targets the specified officials. But there is Clause 9, which deals with other public bodies and other public officials in the wider sense. So this is why I just want to say two things. The definition of specified public body and specified public official, those definitions depend on the definition of public body and public official respectively. Those are really, elaborations of those basic definitions. So you have the basic definition of public body, the basic definition of public official, and then we are elaborating, we are carving out another category of specified public body and specified public official. So those definitions depend on how we define public body and public official, and what we're doing is carving out a specialization, so to speak, out of the basic terms public body and public official.
Understood. But I think there's also a question that Ms. Aldred raised in terms of why include security forces in the first place.
Because, Madam Chair, we have the basic we are not making the policy. This was an issue that was discussed at length last year. So why the terms have been square bracketed on page 8 is for that very reason, because we would have to define who we mean as public officials, and the question that was to be decided by the committee was whether we were going to keep a reference to members of the security forces as part of the scope of public officials. So that's the only reason why the term appears here. It appears in brackets for consideration, whether we should keep them. But we would have had to have the term there if a decision was made to include security forces.
I think that we need to make that decision first. Go ahead, Member Gill.
So Mr. Edwards, you would have indicated why you included in brackets enforcement, but I just want to understand the context in which we'd be using the term enforcement in this case as it relates to the security forces. Just the context.
Well, in terms of the functions relating to tobacco control, as you had pointed out, Senator, the activities or functions could include enforcement activities, which would include law enforcement activities in relation to tobacco industry activities. So that would have been one reason why we would have included members of security forces within the scope of persons in relation to whom interaction should be controlled.
But they would have been captured in specified public...
No, with respect, Madam Chair, the term security forces is not used generally in this bill, in this context. We would have had to create a specific context for this part to use security forces here.
Because of the fact that they are not mentioned anywhere else, right? That is what is creating my little confusion, because you're not using them anywhere else. So why specify them here?
And also, if you are looking at the definition of specified public body, the implementing or enforcement, you have it in the brackets, of public health policy with respect to tobacco control, that would include the security forces.
Yes,
it would include such?
Yes, it would. It would.
Right.
It would.
So.
But to put it beyond doubt, that's why we have included a reference to them in the definition, to put it beyond doubt. So, but of course, that's a question of a decision to be taken by the committee.
On that note, the chairman is here. I will demit temporary office.
Okay, thank you very much. Let me thank members and apologize for being late. I actually had a clash. I had to address a function at the university. But thank you very much, Senator Longmore, for taking the proceedings to this point. I also would like to say, sorry again about this, that we're going to have to leave here at 12 because I understand that they need the Parliament, the chamber, to prepare for the Prime Minister's presentation. That's what the request came to me, so I'm just saying, right? All right, and I also want to apologize for the non-meeting last week. Really sorry about that because we really want to get this going, but circumstances beyond our control. All right, so in the interest
Minister,
of time...
on that point, sir.
Yes.
I think I can't speak for other members of the committee, but I was very disappointed because you played fast and loose that particular day in just canceling the meeting at the last minute. I mean, I understand, yes, I understand the reason for it, that you had another engagement, but you could have passed on information to the clerk from the night before and tell us something, you know?
Actually, I take the point, but just to be clear, I did not have another engagement. This is for last week, you meant, or this week? Last week. I was ready for the meeting, and I must admit my own disappointment that the meeting did not take place, and I did express it. I'd prefer not to express what I expressed then here. Well, let me just finish. But there was an issue in regards to documentation and some consultations that should have taken place, which I was under the impression had taken place. So I am and was perhaps more frustrated than you and disappointed. But beyond that, and that was the last hour, literally the night before, information was passed, and I would have assumed that it would have been passed to everyone, because we do have a mechanism to notify. But the late notice was unavoidable, and the non-meeting was as disappointing for me as I believe it would be for you and other members. And it wasn't because I had another event. It wasn't because of me. All right? Just to clarify. Thank you very much, though. Okay, so I want to just go right into Clause 7, I'm told. What's the decision? I have to bring myself up to speed here. Is there an alternative interpretation, or what's the preferred interpretation? Mr. Edwards, you want
Chair,
to?
Yes, Chair. Where we are at now is really a question of the scope of the officials that that the committee would wish to recommend should be covered by these restrictions on interaction, whether it should include security forces. That's really where we are at now. So we're on page 8.
Right, so I see that. So I'm saying the discussion as to whether any member of the security forces and the Jamaica Constabulary Force, Jamaica Defense Force, Rural Police, specified public body whose functions include the development, implementing, enforcement of public health policy with respect to tobacco control, and the rest here about specified public official, meaning a public official who has functions in the capacity as such to have a role in developing, implementing, enforcement of public health policy with respect to tobacco control. Is it that members are going to comment on this?
I think the question really is whether members of the security forces should fall within the scope of application of this.
Right, so I'm asking members to comment, or did you comment before I came in?
Chair, I think the members are somewhat swayed by the suggestion from the SG in that the security forces would have already been covered by our definition here of public, specified public body, because they'd be part of the enforcement of any measures under the legislation. So it would be, if I may, redundant to have them as a definition within the bill here.
Okay.
So just to clarify, it was the pro tem, is that the correct term? Pro tem chair? It was Madam Chair who had pointed out that the words enforcement are in the definitions, and enforcement would include security forces. So I think the issue is whether you want to take out the square brackets in specified public body and specified public official and keep the words. And if you keep the words, you would delete the definition of security forces.
Okay, our members agreed on that?
Yeah, I'm in agreement with that approach, Chair.
Okay, all right. Mr. Edwards and the team, you're so advised.
Thank you, Chair.
Okay, can we move on to...
Excuse me, Chair, just a question. Was there a decision on the or enforcement in square brackets in the definition of specified public? But then when you look at the provisions don't contemplate that you're dealing with somebody dealing with enforcement. It would be targeted more at somebody involved in developing and implementing policy. I'm just thinking enforcement isn't carried in those provisions.
I'm having that difficulty as well, Chair. It seems to me that we're sort of pulling in the security forces, but that's not really what the mandate of the bill suggests.
So what does that mean in terms of the interpretation and the inclusion of the clause?
But Chair, in my view, I don't think the delineation of security forces is helpful. I think the general definition of public official and specified public official, and we don't need to pull out security forces and extricate it to speak of enforcement. I think it's covered. I honestly don't think it's necessary. And it is going to cause further amendments to have to be made. we can't just drop in or enforcement in these two definitions.
What's the difference between what you're saying versus what the SG was suggesting? I'm trying to catch up.
Oh, no, we're not in conflict, but SG can speak.
For my clarity, can you explain what you just said a while ago? Because I'm still befuddled.
I'm saying that the way the definition of public official and specified public official is crafted, without the words in square brackets, of course, it isn't necessary, in my view, for 7B to be there specifying any member of the security forces, because the words that precede it are so general that it does in fact capture members of the security forces. And if you put our enforcement in the definitions, you then have to look back at the provisions that follow that discuss what duties they must carry out, what are the constraints, and you will find it doesn't really speak to enforcement. That is my concern, sir. That's my concern.
Okay. So what does that mean, Mr. Edwards, in terms of the adjustment?
Well, when we look at Clause 8, Chair, Clause 8 speaks directly to enforcement. 8.1 speaks to the exception in relation to interaction is for activities involved in effective tobacco control and enforcement of the laws. So I'm trying to understand why enforcement.
From the perspective of policing.
No, but we have to look at enforcement broader than just police. Enforcement would include, for instance, public health officers, the actions of anybody, not just police officers.
That's the point. That's why I'm saying, why are you pulling out security forces?
No, but
if you leave it general, it includes them.
No, but I thought the committee had agreed that we would take out the reference to security forces. I thought that decision had been made to take in the definition. The issue I thought was the definition of specified public body and whether we keep the words or enforcement. I thought the committee had already decided to take out the references to security forces.
Yeah, so that was my understanding from what Member Guy and the SG's intervention represented. And that's why I wasn't sure.
But I'm asking about the words in square brackets in the definition, because you don't really have provision that say that enforcement from the perspective of how 640 forces now would be involved in enforcement. Why are you putting them in the definitions? It's not necessary. That's my view. I don't think you need to put the words in square brackets in the definitions for well, I don't want to prolong.
Am I not therefore? No. Question, Chair, please. Ms. Wilkins, you are basically saying that we should exclude the or enforcement because they are already covered. We have already decided that the security forces definition will not be in there. But the other aspect of it is not only the security forces who, to my mind, would be involved in enforcement. You're looking at public health inspectors as well, who may be part of the whole gamut of enforcement officers. So I think it would be prudent for us to continue to include enforcement in it, having regard to the fact that it's not only security forces who might be responsible for the enforcement. I am guided.
Very well, member.
Chair,
are you clear on what was said, or you still have an issue?
I'm clear.
I really want to do it right, despite the length of time it's taking. So if you are clear and we are aligned, can we move on?
Chair.
Is that okay?
With respect, Chair, can we not move on yet?
Okay, go ahead.
Chair, I think the point that Ms. Wilkins is making is an appropriate one, and I would just reference the square brackets means a public body whose functions, specified public body means a public body whose functions include the developing, implementing, or enforcement of public health policy with respect to tobacco control. The distinction between the public health inspector and the public and the security forces at large, I think, is what is troubling me and perhaps might be troubling Ms. Wilkins, because while the public health inspectors have a very specific mandate, which is derived from the public health policy, the security forces, and if by security forces we're talking about what we ordinarily speak of, which is the officers, the members of the Jamaica Constabulary Force, and in some instances, members of the Jamaica Defense Force, then they have a mandate to enforce the law generally across all areas of policy in the country that are reduced to law. So to include them here, to me, I'm not quite sure if the purposes of the policy vis-a-vis the restrictions that we then put on them is justified based on what it is we're trying to do. So I would just ask that we kind of take a deeper look at this one. I don't think it's a simple matter of just putting in enforcement, because I agree that when you come down to 8.1, body or public official may only participate in interactions with the tobacco industry to the extent strictly necessary for effective tobacco control and enforcement of relevant laws. Here we're talking about enforcement of relevant laws, and in the definition, we're talking about the policy. So I feel there's a little bit of confusion.
To add, let me just add that in the section, in the part of the bill dealing with enforcement, these terms, I'm not seeing a proposed amendment to incorporate any term that would be consistent with the change we're making to, or the definition, including or enforcement. We have an enforcement section. It doesn't say specified public official. It doesn't. It speaks about authorized officers. So I'm saying.
So you're basically saying that greater clarity is needed and a more all-encompassing term as opposed to specifically identifying one subgroup of enforcement. Is that what you're saying?
Chair,
or something also, like that?
I'm saying that, but I'm also saying, is the policy imperative to include JCF and JDF officers? Is that the intent? Because that seems to me to be a bit broad and a bit of an overreach in terms of what the policy is trying to do.
Mr. Edwards, do you want to come in on this, please?
Okay. Yes, Chair. The intent really is to focus on those bodies that have a particular role in relation to tobacco control. So we do agree that the law enforcement from the security officers is broad-based. So they would cover everything in the jurisdiction that would relate to enforcement of laws, as opposed to having a specific role in this context. So the intention really is to focus on entities that have particular functions relating to public health activities, and more specifically, public health in the context of tobacco control, which would not be the police. Police, with for all intents and purposes, do not have that focus of their activities. They are broad-based in terms of law enforcement. So the intention would be more relevant to somebody like a public health inspector, because that is a targeted function of somebody in that context, as opposed to a police officer who is dealing with all breaches of any law.
Yes.
Chairman, I think perhaps we can, I am motivated to find out exactly, I think as Senator Golden is probably alluding to, what really is the purpose for specifying these officers. In my mind, it is covered under persons responsible for enforcement, etc. But I wonder if we can reflect on perhaps what obtains in other jurisdictions, or if there is some requirement in terms of a requirement of us being signatories to something else that indicates that we need to specify this set of personnel. If not, in my mind, I think we have it covered, and I think we don't need to add any duress to this group of officers where it is not necessary. Thank you.
If I may, I promise this is my last on this issue. The definition of authorized officer. In the enforcement section, we only speak of authorized officer. So the definition of authorized officer governs how enforcement is treated. The word implementing in the definition of specified public body and specified public official is adequate to cover them putting the public policy in effect and ensuring that it is placed in effect. I don't think we need our enforcement.
So your read of it would be then, Ms. Wilkins. What would be your read of this particular part then? Give us a suggestion.
I have no difficulty with it, save for the words in square brackets. In terms of the definition of specified public body and specified public official, and certainly the removal of security forces from 7.
We took the decision on the security force, so it's really square brackets that you're concerned about. Madam SG, are you comfortable with that?
Yes, very.
All right, let's go ahead. Let's proceed then. All right. So
Chair,
can you
I'm so
read?
sorry. May I just ask one question, please? I'm so sorry. Did we amend the definition of authorized officer? I'm just asking for some clarity, because that, of course, includes the very members that we were just discussing.
No, I don't think we
There
did.
was no decision to amend. To amend that
But
definition.
based on what Mr. Edwards has just said, the inclusion of these members, you know, JDF, constable, etc., isn't the intended target of clause 8. But is it correct then, Mr. Edwards, they are appropriately placed in the definition for the purposes of part 9 enforcement? I just want to just have that clear.
Yes, I would appreciate that they're correctly placed there in that context for part 9.
Okay, thank you.
Okay, so Mr. Edwards, can you reread or read the further adjusted clause, please? As we have agreed.
Yes, Chair. So the adjustments would be that in clause 7, the definition of public official would no longer have a part B. So there would be no A. So it would just read public official means a person who performs a public function, holds an office of employment to a public body, or is a parliamentarian, whether the person is appointed or elected, whether permanent or temporary, or whether paid or unpaid. And everything else would be deleted from that definition, the paragraph B, and then the security forces definition would also be removed. And then in the definition following of specified public body, the words or enforcement would be deleted. So it would read specified public body means a public body whose functions include the developing or implementing of public health policy with respect to tobacco control. And similarly, the definition of specified public official would read means a public official who has functions in the capacity as such that have a role in the developing or implementing of public health policy with respect to tobacco control.
Okay. Are we agreed? Members? All? Yes? Okay. Silence in this case is consent. Thank you very much. Can we move to clause 8? And Mr. Edwards, there were some proposed changes, I believe you had the assistance of the...
Chair, we had actually started clause 8 as a result of the definition discussion. So the first question would be whether we use may or shall in the context of 8.1. I mean, we would suggest shall, but it's for the committee to decide, because in the context of the fact that there are some sanctions, shall would seem to be more appropriate.
I would have to be advised legally whether may or shall is more appropriate. What is your proposal?
May is empowering, shall is prohibiting. So in the context that there is actually a sanction if one does not carry out this action in the manner specified, then we believe that shall would be appropriate.
Okay. That's a proposal. Are we all agreed on that? Yeah? Okay. So let's proceed on that. And then...
Change, Chair, was conducted under acting chair, where the decision was taken by the committee that in subsection 3, instead of the words appropriate or authority, we would use language that would speak to the specified public official being required to state in writing to the authority that would have responsibility, the specified public body that would have responsibility over the actions of that public official, in the context of being the public body that the official was employed to, contracted to, or served within.
Right.
So we would add that language. So that was taken.
Okay. And there's agreement on that. Okay.
Yes.
Proceed.
And of course, the words that are highlighted, we believe are now being accepted by the committee as language for this section, specified public official. So there were no other changes.
Chair, excuse me, Chair.
Yes, go ahead.
In 8.2, I'm suggesting the last line, participation with at least one other specified public official, that you insert the word specified.
Okay.
Just a point here to Mr. Edwards. Mr. Edwards, I'm thinking that it may you never know what the context is, but in the event that there is a logistics difficulty, I'm wondering if we shouldn't use, instead of using this mandatory language, if it shouldn't say something like should in as far as it is possible, rather than the mandate in the shall. What if it isn't possible to have the joint participation of another public official, depending on the circumstances? You wouldn't want to know that they aren't able to do what they're supposed to do. So I'm just thinking that we should have it as a rule of thumb rather than a mandate. Just putting that out there.
You're talking about 8.2.
But this is okay. So we're talking about a case where the.
Yeah, but before you elaborate, Mr. Edwards, Mr. Wilkins, you're basically saying that you're giving an out to the individual to say, okay, it's a CYA, so because of logistics, I wasn't able to have another official there. I think we're opening a can of worms that we don't really would want to have happen. And I think if it is a situation where it's logistically not possible, then we should have that particular individual defer it to a time when it might be logistically possible. I personally don't think that we should put as far as practicable, because we are always giving an out to that individual.
Yeah, I'm inclined to agree with it.
But notice, that prior to such a meeting, they must state it in writing to the appropriate authority. So some notification will have been given prior to the meeting taking place based on 3. 3 said before commencing any interaction, they must state it in writing. So I'm thinking that if that's there, but not to worry.
But that actually emphasizes the point in our view that you should not give
I'm inclined to support what is there and the supporting argument advanced by Member Guy.
The intention was in the first instance, the meeting going to take place or not going to take place. If both of you aren't there, it's not going to take place.
All right, so let's accept that and move on. What, Mr. Edwards, you want to continue?
The committee had agreed in subsection 2 to add the word specified before public official. Yes. Yes. Specified public official. Yes. Yes, Chair. So in subsection 5, the word specified is in brackets.
Sorry, Mr. Edwards, before you get to 5, in 4, at the bottom of page 9, submit it to the relevant. Is it the specified public body? And then, of course, it has the words about the appropriate authority.
I think he addressed that, didn't you?
For 4. So I don't know if he addressed it. It says relevant public body, but we are using specified.
Yes. Yes, Chair. What SG says is correct. It really should be specified in light of our earlier decision. Specified public body.
All right.
And again, in subsection 5, the word specified should be retained and the brackets removed as specified public body.
And I suggest it be inserted right at the end, specified public body.
Yeah, that's right.
Okay, Mr. Edwards, proceed, please.
Yes. Okay. All right, so as I'd indicated, Chair, before your arrival, the intention was that we only highlighted where changes would have been made since the last meeting. So unless there are any other points that members wish to make in relation to 6, 7, or 8.
Chair, I'm not a member, Marlene Waldred. As it relates to 7, it speaks about an offer of hospitality. It's a very vague term. I'm concerned about it because there are penalties attached to this provision. So if you're going to sanction someone, you have to be very specific and precise about what you're going to sanction them about. What do you mean by hospitality? And I'm actually not even sure this clause is needed when you look at everything else. Meaning, if you look at the clauses in totality, I don't know that you need 7. A public, well, can't even say public body, public official shall not accept any offer of hospitality.
What would you replace hospitality with? Because I think the intention here is to avoid gifts and by extension influence.
But look at 8 below.
Sorry?
Right. Look at 8 below. And I'm saying when I look not just at 8 below, but throughout. So the rest of that, I don't see why you need 7 if you have 8. A public body shall not accept or any direct or indirect funding, endorsement of projects, partnerships, activities. I mean, it goes on A, B, C, D. With all of those matters, what is missing that you need 7?
And if you look at 8C says the same thing.
But I'm not in favor of 8C because I still think it is too vague. Yes, but I see your point that it is already repeated.
Yeah,
yes.
I see the repetition and I accept that. Yeah. I'm trying to determine
Chair,
what is the
So can I say then, Chair, look at D, accept from the tobacco industry any proposals, drafts, offers of assistance. in our general understanding of hospitality. Wouldn't that cover it? I would think it covers it. But my problem is the term itself, hospitality, is vague. And then you're going to apply a sanction. I just don't think it's needed at all. I think if there's a gap, then you address the gap.
Mr. Edwards, what was the rationale behind hospitality? I mean, I'm interpreting it as extending certain courtesies that provides a benefit of some kind.
It will be...
if that is captured and we're convinced it's captured elsewhere, then I don't want to be repetitive. But what was the justification?
The intention was to cover activities that may not be as easily traceable as, tangible gifts. So it would cover things like, restaurants, engagements, offers of accommodation, assistance, that type of thing. Those kind of courtesies which cost money and which are attractive to people and which could help to influence the actions of people, but are not tangible.
So is there anywhere otherwise that is covered? Because I do appreciate, football tickets, restaurants, that kind of thing.
Right, and that is more appropriate for something like guidelines or a code of conduct, but not for a law where you're going to put a sanction. And that's the problem I have. You're putting a sanction on it. So you're going to go to court, you're going to charge someone, and they're going to go to halfway tree to answer to what charge exactly?
But in this context, Chair...
Or sorry, disciplinary proceedings.
This is disciplinary, this is not court.
Yes, but it's almost the same. You have to treat disciplinary proceedings almost at the same standard. So I'm going to be charged with what exactly? And I'm going to go before a tribunal to respond to this? This is really more appropriate for a guideline.
Senator Allen is online. Let me hear what she has to say. Senator.
Thank you very much, Chair. And I remember this being a very actively, this was one of those points that went back and forth for a while. I agree with the SG, and I believe in 8A, a lot is captured in 8A, which might be the based on intention that Mr. Edwards pointed out, where it was like things that are very hard to identify, whether tickets or accommodation, etc. It says in 8A, including public bodies shall not, and it goes on, including taking part in any initiatives or participating, endorsing. No, not that part. It was talk about accept from the tobacco industry any direct or indirect financial or resource contribution or become involved in endorsing any manner. And it goes on to assistance and development or implementation of a tobacco policy. I think if we're not careful, we could be going so wide with hospitality. I really believe that in 8A and B, much of what could be the issue is addressed, and then anything else, as you pointed out, could be addressed in guidelines.
Sorry.
Hello?
All right.
Chair, I listened to the Solicitor General, and I think back in terms of when you are, as an entity, seeking to impose a sanction of a disciplinary matter, you ought to be very specific. Because even the defense of that disciplinary matter, in contesting it, you would have to contest it based on the specifics. Now, hospitality is very broad in nature. What is contained in 8A is wide enough, in my mind, to cover any of these eventualities. I understand, Mr. Edwards, what you'd be seeking to capture if, the entity has a booth at Sabina Park and invites someone. It is not permissible. I understand you're trying to prevent something like that. But hospitality is so wide in nature. I could stop at the house of a member of Carreras at a party. I can't take part. No.
All right, so I'm looking at
so
it.
8A, Chair, I believe, covers all of this, and we don't need.
Well, technology has allowed me to quickly bring up the definition of hospitality. And it says the friendly and generous reception and entertainment of guests, visitors, or strangers, business of providing food, drink, and accommodation for customers of restaurant, bars, guests, hotels, etc., etc. So, you know, I don't want to prevent a citizen from extending generosity in a time of distress and then run the risk of being prosecuted for it. But at the same time, we have to